Court is in session in cause number 326-380, case of Style of State of Texas versus Keandre Jones. Mr. Jones, is that your full name?
Yes, sir.
Mr. Jones, would you please raise your right hand? Mr. Jones, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. Jones, you may put your hand down. How are you doing, Mr. Jones?
Good.
That's good. Mr. Jones, I have before me an information that alleges that on or about February 24th of 2020, while you were in Jefferson County, Texas, that you committed the Class A misdemeanor offense of interference with emergency telephone call. Mr. Jones, do you understand what you've been charged with?
Yes, sir.
And to this charge, Mr. Jones, how do you plead guilty, not guilty, or no contest?
No contest.
And now, Mr. Jones, are you pleading no contest freely and voluntarily?
Yes, sir.
And are you pleading no contest because you do not wish to fight or contest the charges?
Correct.
Mr. Jones, I have before me several documents. The first document is titled Judge's Explanation of Rights to Defendants Without an Attorney. Mr. Jones, do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant?
Yes, sir.
And are these your initials on the line that states I do not request an attorney, I desire to represent myself? Is that correct?
Yes, sir.
Now, Mr. Jones, I also have before me a document that is titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. Mr. Jones, do you recognize this document?
Yes, sir.
And is this your signature on the line that is titled Defendant?
Yes, sir.
Mr. Jones, I also have a document before me that is titled Misdemeanor Plea Admonishment. Mr. Jones, do you recognize this document?
Yes, sir.
On page 2 of this document, Mr. Jones, there's a set of initials. The first set of initials is on a line next to a box that says check no contingent, which means no contest. Are these your initials?
Yes, sir.
The second set of initials is below a paragraph that's titled Discovery Admonishment, and it is on a line that states, I do not request discovery of the evidence. I waive my right to request discovery in this case and choose to enter a plea of guilty or no contest. Are these your initials?
Yes, sir.
On page 3 of this same document, there's a signature above the line that is titled Defendant. Is that your signature?
Yes, sir.
I have another document before me that is titled Trial Court Certification of Defendant's Right of Appeal. Mr. Jones, do you recognize this document? Does it speak up?
Yes, sir.
And is that your signature
Yes,
on
sir.
this document? There are 2 boxes that are checked at the top of this document. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that?
Yes, sir.
The second box states that you are waiving your right to appeal, which means you're giving up your right to appeal. Do you understand that? Now, Mr. Jones, prior to signing and initiating all of these documents that I have just mentioned to you, did you read the documents?
Yes, sir.
And did you understand what you read?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
State, I have before me State's Exhibit number 1. State, you like to offer State's Exhibit number 1 and State's Exhibit number 2, the probable cause affidavit?
Yes, Your Honor.
Mr. Jones, I have before me State's Exhibit number 1. State's Exhibit number 1 is the document that have your initials on page 2 and your signature on page 3.
Yes, sir.
I also have before me the probable cause affidavit. The probable cause affidavit is commonly referred to as the police report. The state would like to use both of these documents as evidence against you in your case. Is it all right for the state to use these documents as evidence in your case?
Yeah, fine.
Hmm?
Yeah, yes, sir.
Oh, it's all right. All right. Now, Mr. Jones, State's Exhibits 1 and 2 will be admitted. Mr. Jones, is there any evidence that you are currently mentally incompetent to stand trial? Do you have any mental problems? Do you understand what's going on?
Yes, sir.
You understand the consequences of you entering your plea in this case? All right. And so, Mr. Jones, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. and I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
Yes, Your Honor.
And what is that agreement?
It's 40 days county jail. Mr. Jones has credit for 40 days time served. The court cost to be taxed and retired.
Mr. Jones, the state is offering that you serve 40 days in the Jefferson County jail. You will not have to serve any time in the Jefferson County jail because you've already served 40 days in Jefferson County jail. Therefore, you will be given credit for time served. The court cost in this case is $457, but you will not have to pay it $457 because the time that you spent in jail has already paid it off. Therefore, the $450 court cost will be taxed and retired. Mr. Jones, do you understand the state's offer? Do you think that's, you have to speak up.
Yes, sir.
Do you think that the state's offer in your case is fair and just?
Yes, sir.
And do you accept the state's offer?
Yes, sir.
Okay, Mr. Jones, I'll follow the plea bargain agreement that you have entered into with the state. Mr. Jones, you're gonna stand on the X.
And Your Honor, this is interference with emergency call with the family violence element, which that is alleged in the PC. If you look at the PC on it.
Hold on a minute. If that defendant interference to which an emergency call request is from a law enforcement, I don't see that in there. It's not in the next time. Forty-two point oh six two.
It's not in the information itself, but it was in the AS 400 as that.
Yeah, let's see, 42.0. There's no, I'm just looking at the definition of interference with emergency request for assistance, section 42.062 of the Texas Penal Code. There is no offense for family violence in that section. And I don't think this is not a Title V, because pursuant to, let's see, pursuant to just have that. Okay. Pursuant to 42.013, finding of family violence. In the trial of an offense under Title V Penal Code, if the court determines that the offense involved family violence as defined by Section 71.004 Family Code, the court shall make an affirmative finding of that fact and enter the affirmative finding in the judgment of the case. Let's see. This case is filed under Section 42.062 of the Texas Penal Code. And 42, that is a Title IX. 42, yeah, that's a Title IX offense. In order for the court to make a finding of family violence, it has to be a Title V offense. This is not a Title V offense.
Okay, Your Honor.
Yeah.
I guess with that, if we can, I'll get them to switch it upstairs in AS 400, because it's not like that in the information, and it's not.
In the information, it doesn't read family violence.
Right, it's only in the PC and.
Hold on, let me see the judgment.
Uh,
It's something, let me see the judgment. Yeah, emergency, okay. But the judgment doesn't have family violence in it either. Emergency with, yeah, I mean, it's on your,
It just happened on my hand.
no, but I'm just saying, this judgment doesn't have a family, it doesn't have a charge of family, it just has interference with emergency call. So for some reason, and then on the information, it's interference with emergency call.
Yes, sir.
And so it's consistent, it's not, the judgment does not deviate from the information. And in fact, and just for the record, the court is not making a finding of family violence. One, because by statute in the penal code, there is no family violence for an emergency call. And two, pursuant to, I think it's 42.013, it has to be a Title V offense. This is not listed under Title V, it's listed under Title IX. So unless you show me a statute that says Title IX, at this time, the court is not going to make a finding of family violence.
Yes, Your Honor.
And this judgment is consistent with the court's finding. Okay?
And I'll get them to switch that just to make sure that it works with the clerk's office. And
Right.
everything's,
Right. So, Mr. Jones, you can stand on the X in front of our court coordinate, in front of our court clerk, and you can follow her direction. Once you finish following her directions, you'll be free to go, and you have a blessed day.
Yes, they have to.